car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis, Wright, and host David Lamb.
Hello and welcome into The Attorney. Thank you so much for being with us tonight. Here's the way things work for the next half hour. So you'll see at the bottom of your screen ways that you can call, text, email, get in touch with us. We love to hear from you. Also, Hollis Wright makes available each and every Sunday night attorneys standing by live to take your call. So that's a free, confidential, off-air phone call or text or email that you can send and communicate with them however you choose to do so, but the opportunity to communicate with an actual attorney standing by live. We also happen to have a couple of attorneys standing by live leading our conversation tonight. He's from the firm of Hollis Wright. Carter Clay, good to see you, sir.
Good to see you, David Lamb. Hope you're doing well.
Doing very well, thank you.
Yeah, so tonight we're going to be talking about what to do when a loved one passes away in terms of the assets and property that they have. Of course, we hate it when a loved one or family member passes away, but it's absolutely inevitable. Everybody at some point in their lives will have to deal with that occurrence. And the question becomes, after you go through the grieving process, okay, the loved one or the deceased person had X, Y, and Z assets. What do I do? And a lot of times you may be the unfortunate or fortunate one in the family that all the other family members look to give guidance and direction in terms of the steps that should be taken. And so that's what we're going to be talking about here tonight, is what to do with those assets. How does a will impact those assets? And if the loved one who passed away does not have a will, what happens to those assets? And we're very fortunate this evening to have Kayla Schoen on the show with us. She's a seasoned veteran here on the show. She does an outstanding job with her clients. I know she's basically got a general legal practice. I'll get you to talk a little bit about that in a minute. But David, she worked with us a little bit during law school, and now she's been out. I hesitate to even ask how many years you've been out practicing because it makes me feel so old. But
I know.
How many years is it now?
It's going on 5.
5 years. Wow, that's incredible. But I know you're working hard and doing great work again for your clients. Introduce yourself to the viewers and tell us a little bit about the nature of your law practice.
Sure. So my name's Kayla Schoen, and I have sort of a general practice. I specialize in probate. I've also been fortunate enough to dabble lately in immigration law and have really enjoyed it. I do some general contract work for small business owners, and I'll do uncontested divorces. When it gets contested, I'll send those to more knowledgeable people who have more patience than I. But I do enjoy uncontested divorces, so just things like that.
Doing uncontested divorces and passing off the contested one, that is a sure sign of a very smart, intelligent lawyer. Right
I know what I'm doing, yeah.
Well, we're not going to tackle divorces tonight. We're going to talk about what to do in the event that a loved one passes away and you're the adult kind of tasked with the responsibility to figure out what to do. And tell us a little bit about, we've all heard kind of the expression, whether it be on TV or just around restaurants, about, well, I got to go probate a will.
Sure.
First of all, talk a little bit about a last will and testament, and what does it mean to probate a will?
Sure. So not a lot of people, sadly, have a last will and testament for a variety of reasons. But if you do have one and your loved one goes to administer your estate and handle those affairs, we call it probating a will. Probate literally means to prove or to validate a will. And so the process of submitting that to the probate court with some other documents and getting the estate open is the probate process.
Now, who would be the person that would be assigned the responsibility to take the lead on getting a petition to a probate court for probating a will?
So the simplest answer is, if you have a will, you will name a personal representative. Sometimes it's also called an executor, and you will hopefully have named a backup as well. And so it's typically that individual who will know where the will is, who will have a copy of the will or the original will, and will take it to the probate court to have that done. It can be other relatives who find it going through their loved one's home or something like that. But generally it is the personal representative named in the will.
And what advice would you give the viewers, because we do phone banks where we get a lot of different calls about different legal questions, and sometimes we get calls from people saying, well, so-and-so family member died, I know they had a will, we cannot find a copy of it, what do we do? What advice would you give to the viewers in terms of the number of copies they should have and who should have copies and the safekeeping?
Good question. So I normally give my clients obviously multiple copies and tell them, you know, keep some for your records, obviously properly sign and have witnessed and notarized one, and know where it is, keep it in a safe place, and tell your personal representative where it is, tell another family member where it is so that people know, and then keep copies, maybe one at your office or maybe one at somebody else's home or something like that, because you can submit a copy of the will. There are some added steps. They prefer the original, but you can submit a copy.
Now, in terms of the personal representative or the executor, having a copy of the will, the family member passes away, they look at it, okay, I'm supposed to be the personal representative, the executor. Is the petition to probate the will, is that typically something that's done without a lawyer, or what advice do you give the executor in terms of should they immediately come to an attorney and have the attorney start that process?
I'm not just saying this because I am an attorney who likes to get hired, but
every single person should come to an attorney.
I do not see very often people operating in probate in that manner without an attorney. We call it pro se, as you know. That means on your own, kind of. And you don't have to have an attorney to do really anything in the law. But it's a really complicated process, and I just don't see people moving forward without one very often at all.
Yeah, and it's not an area of our law practice at our law firm, but I have seen those types of petitions, and there's a lot of legal terminology that's included in those petitions. So you really have to have somebody with some level of expertise or experience in filing a petition to probate a will to do it correctly, because obviously there can be consequences of not doing it correctly.
Yeah, and even I get caught up in various situations. I'll go to file something in the clerk's office, and one little, different language in the will may require a motion to interpret the will, or me serving someone, special process server or versus publication. There are just some nuances that even attorneys, I think, it's just a complicated area of the law.
Yeah, and I guess if the person that passes away did not have their will done or drafted in too far back in time, they can always go, and a lot of times they probably do go to the attorney that actually drafted the will for the family member.
Sure, I see wills 50-50. I put on mine typically drafted by myself so that family members could find me if they have questions or anything, but some don't. But yes, you obviously could.
Now, where are these wills probated? Do we need to take a break? Or
we can. Can we step aside
right
here?
Yeah, we can step aside. That's a good point.
Yeah.
Hold that thought.
Got it.
Right there. Well,
it's a good segue.
Yeah, there you go. Nicely done. You can tell y'all done this show before.
Yeah,
you can tell for sure. Hey, as we head to our first break, a reminder, Hollis Wright all over social media as well, Facebook, Twitter, as well as Instagram. If you search the term Hollis Wright, you'll find them there. They use that really neatly as an educational kind of informational tool and another way to dialogue with you. So get in touch with them and check them out on social media. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back in to the attorneys. A reminder before we return to this conversation with Carter and Kayla that attorneys from Hollis Wright are standing by live to speak with you. That free, confidential, all-fair conversation. All you have to do is pick up the phone and give them a call to make that happen. Carter?
Yeah, sure. Kayla, lawyers tend to take certain areas of information for granted, one of which is, I guess we should probably tell the viewers that every county in the state of Alabama has a probate court, correct?
That's right.
All right, and so given that, if you've got a loved one that passes away, you've got a will, the representative has the will, they're ready to take action and get to an attorney, what are the options for those individuals in terms of which probate court they can file their petition to have the will probated in, and what are the restrictions and limitations in terms of where you can file?
Sure, so it's pretty simple. It's either where the decedent resided, so if they lived here in Jefferson County, you would use the probate court here in Jefferson County, and it could also be where they had property.
Okay.
Yep.
So it could be a combination of those two.
Sure.
All right, a question we've got here. My loved one died with no spouse, no children, and no property. Do I have to probate their estate?
That is one of the most common questions that I get. They'll say, why do I have to do this? And the answer is you really don't. It's a case-by-case basis, and I ask a lot of questions of my clients of what is in the estate and why would we need to probate it, and really it boils down to two big questions for me. Is there property in the estate that was in the sole name of the decedent that we've got to probate the estate to get it into somebody else's name so it can be handled like property?
Okay.
Or does an estate need to be opened to handle a lawsuit related to the death of that individual? And so that sort of ties in. I know Hollis Wright has that from time to time in like a wrongful death suit.
Yeah, and talk a little bit about this, because there are a lot of assets that are out there that can be handled outside the will or outside of an estate. And I know one common example is like life insurance proceeds. So if somebody has a life insurance policy, they're going to designate a beneficiary of that life insurance policy. That clearly is worth money.
Yes.
But it's not an asset, as I understand it, that would be subject to probate, because when the person dies, whoever their designated beneficiary is, basically I guess they just show them the death certificate. Here's the person that was covered. I'm the beneficiary. Pay me my money. And that's not subject to the probate process, correct?
Right. Anything, I try to categorize it like this. If it's a private contract, it's outside of probate. So you're right. Life insurance policies, you know, any sort of like pension plans, things like that. And another way to sort of avoid probate if you can, and I advise my clients to do this, either make your bank accounts, check accounts, savings accounts, either make those payable on death to an individual or make them joint on the account. So that doesn't have to be probated. They'll have to get letters of administration or testamentary, go to the bank. You can kind of avoid that slowdown by doing things like that.
Yeah, and I think another big example would be home ownership. So we've all gone to buy a house and somebody says, well, do you want to be joint owners with your spouse with right of survivorship? And a lot of people are like, well, okay, if that's what I'm supposed to do, I guess I'll do it. But the reality of it is that has real world consequences, which is that if one person dies, the joint owner just takes ownership. That's what that right of survivorship means. Is that correct?
That's exactly right. That's the best way to do it. And I have clients who often in preparation for that time of life will make those changes if they haven't already. Will change their deed to say joint tenancy with right of survivorship to whomever they want their home to go to, so that it doesn't have to be probated to make that happen.
Talk a little bit about the timing of the petition to probate a will. Obviously, when a loved one passes away, they're going through a mourning process. They want to celebrate the life of the person that passed away. So we can go ahead and put their mind at ease that they've got plenty of time to get the petition filed to probate the will, but sort of talk about your advice and recommendations for getting it done, and what are sort of the outer limits, or I guess statute of limitations for lack of a better word in that regard.
Sure. So we actually just had the Jefferson County Annual Probate seminar that I go to every year, and one thing that they emphasize that I did not realize was on the rise, because I don't have this a lot, but you have to wait 5 days after someone passes away to probate their estate. And I guess recently there have been a lot of people coming very quickly to the courthouse to get that started. You cannot wait longer than 5 years. So if you have the will, you need to go ahead and get it taken care of within 5 years. There are some exceptions. If you have proof of certain legitimate reasons why there was a delay, that you can get past that 5-year mark, but it can be difficult. So no longer than 5 years, but wait 5 days and then go do it.
Well, it's interesting, as I indicated earlier, we don't do that type of work except in wrongful death situations, and I'm very familiar with the 5-day rule because a lot of times when people tragically die in an accident, there might be multiple family members that want to serve as the representative of the estate, and sometimes, unfortunately, it can be sort of a race to the courthouse, but nobody can do it until 5 days after the person passed away.
Yeah, got to give it 5 days.
Now, talk a little bit about what an individual can expect when they file a petition to have a will probated in terms of the length of time the process can take, hearings that they might expect to encounter, those types of things.
Sure. So the shortest time frame would be if you had what we consider a small estate. It's also called a summary distribution. The limit of the value of the estate changes every January with inflation, but it's about $28,000 right now. Cannot include real property, and there's about 8 or 9 other requirements that the estate has to meet in order to be a summary distribution. In that case, you can get it done in about 30 days, but otherwise, if it's a typical estate, the minimum is 6 months. We have to keep the estate open for 6 months to allow any creditors to come forward and make claims of the estate, and so there's no way around that. So you're looking at a minimum of 6 months, and that's not including just all the time it takes to file, to have a hearing, to open the estate, to close the estate. So I typically tell people, consider it 6 months to a year.
Okay. You want to take a break?
Sure.
Let's do that. Let's step aside, our final break of the evening. As we do so, a couple of reminders. If you would love to converse with us, we'd love to hear from you. Here's how that can happen. Also, don't forget, attorneys from Hollis Wright standing by in just a few minutes remaining, so take advantage of that opportunity. Stay tuned. We're coming right back.
I'm Josh Wright with the law firm of Hollis Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 4-in-1, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Now, Rule 403 of the Alabama Rules of Evidence states, in part, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule and is to be excluded. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is wealthy or rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there's sufficient insurance coverage or assets to satisfy a verdict. Most likely, the parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during trial, there likely are resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. And remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. And as always, thanks for watching The Attorneys right here on WVTM 13.
Four in 10, not the best odds. Welcome back into the attorneys. This is our final segment. Those attorneys from Hollis Wright standing by live. If you want to speak with them, you got about 8-9 minutes to do so. Carter?
Yeah, Kayla, we've talked about probating a will and that process a little bit, but you brought something earlier. I think there was a firm fact earlier about how many people don't have wills. And so let's talk a little bit about that process, because I think actually the process is if you file a petition to have an estate administered, the process is somewhat similar to probating a will. But talk a little bit about that process, the appointment of a representative through that route.
Sure. So there are a lot of similarities, but you're right. If you probate a will, that's when there's a will, obviously. If you are handling an estate with no will, it's an administration. So that's one, slight difference. The biggest difference to me is that a will, the purpose, as you know, is to list out how you want your things doled out after your passing. There's not that in place with an administration, and so it goes along with the laws of intestacy in Alabama. You don't have control over it, I don't, none of us do. And so typically the way it would go is, first to your surviving spouse. If none, then to your children. If none, then up to your parents. If none, then sideways to siblings, and on and on and on until we find someone.
Yeah, we had a guest on here one time that I think summed it up best, and he said, actually, everybody has a will. It's just the vast majority of people's will is dictated by the state of Alabama.
That's right.
And so you lose that control. And so if you pass away and you have not set out in a will that you have drafted and signed off on how you want your assets disposed of, the state of Alabama is going to dispose of those assets for you.
That's right.
But the process, as I understand it, is very similar to probating a will. You would file a petition with a court indicating that X, Y, and Z assets exist, and that whoever is filing the petition, a family member, and their priorities in terms of who can serve as the representative, and you'd actually have to get appointed by the probate judge to serve in that capacity and administer the assets.
Sure, and one of the other caveats to doing an administration versus a will, most people, and I encourage my clients to consider this, will have language in the will that waives a bond requirement. It's expensive, and it's another step you've got to take. When there's not a will waiving the bond requirement and you have to handle an estate as an administration, you will have to post bond. And again, that can be expensive and time consuming to get that done.
Whether you're the representative of an estate through a will or the representative through an administration process that you just referred to, talk a little bit about the duties and responsibilities of the representative in terms of investigating and identifying assets that are subject to the probate, and the process that they have to go through to, I guess, identify those assets to the court and the disposition.
Sure, so we usually have to submit to the court what's called an inventory or an accounting, and you're right, it can be difficult, especially if that person was private with their affairs. Some people have a pretty good idea about their loved ones, where they banked, obviously their home, their vehicles, things like that, but if it's a long lost relative who's got to come forward and do it, it can be a difficult, you feel like a private investigator a bit.
Question we've got here,
Sure.
My loved one passed away in Alabama, but I live out of state. Do I have to travel to Alabama to handle the estate?
Good question. So no, you don't, but you should probably be named in the will. If you are, then your attorney can go to the court hearings for you. If you are not named in the will, you will likely have to get an Alabama resident to serve as the personal representative.
Yeah, because I think out-of-state residents are not allowed to serve as an administrator or representative of the estate.
Right.
All right, talk a little bit about LegalZoom. And some of these, we see commercials on TV, and we see things on the internet kind of promoting go to LegalZoom and some of these other places where I guess they have sort of a cookie cutter, one size fits all will. Do you encounter people that have gone through that route before, and talk a little bit about your advice in that regard.
Yeah, so one of the things that I enjoy doing quite a bit is reviewing wills. Sometimes people have estate plans that they've created 10, 15 years ago, and they say, why don't you look over it for me and just make sure it's all on the up and up. And I do that and get everything straightened out if it needs to be. But you know, I'm a DIYer, so I understand people wanting to do things on their own, and I get it. But wills, it's not that people don't know how they want their assets distributed. It's not that they don't know that. It's the little nuances, it's the technicalities, the number of witnesses that have to sign, the notarization, and certain language, like I said, waiving the bond. I see that missing from time to time. Sometimes people don't know that they need to name a personal representative. They just know in their mind, well, obviously it would be my daughter. I only have one daughter or whatever. And so without those things, you will encounter obstacles. And so it's the technical legal language that's so important to have an attorney review and draft for you.
Kind of makes that's where the challenge of the layman doing it kind of comes in. We're almost out of time. Just want to jump in just with enough time for both of you to have a final thought. And Kayla, if you would, you go first, please.
Yeah, I love being on the show, and it's just a pleasure being here with you guys. It's my 4th time. I can't believe it. I feel really honored. And so I just want to tell everybody to have a happy holidays, and just to thank Carter and his firm again for having me. It's always a pleasure.
Well, you're welcome. You always do a great job. And I think, just back on topic a little bit, I think there is a bit of a misconception out there in terms of the cost associated with having a will drafted and having a will probated. It's not an incredibly expensive process, and I think to some extent people can be misled by seeing that you could go to LegalZoom and some of these other places online and get a will done for $79.99 or whatever the costs are on there. But depending upon the complexity of the estate and the complexity of the will that you want drafted, I mean, it can be anywhere from $300 to $500 up to maybe $1,500 to $2,000 or more if it's a really complicated situation. But I would always advise people to at least contact an attorney that handles these types of probate matters and or drafting wills. Just get a quote from them. Right. It doesn't cost them anything to get a quote from a lawyer in terms of how much they would charge you. Most of the time, if not all the time, they'll give you an initial free consult just to get an idea of what your situation looks like. So I would always advise people to do that.
Yeah, wouldn't cost you anything just to get an idea of what it's going to cost. Kayla, good to see you again.
Thank you.
Carter, good to see you as well.
Sir.
Thank you all so much for being with us, and as always, we really appreciate you joining us each and every Sunday evening. It's our pleasure to bring this show to you, and it's been another great year thanks to you who've been a part of this process as well. As we wrap things up, a couple of reminders. Even though we're going off the air, you can still contact the firm right there. Check them out on social media as well. Thanks so much. We'll see you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.